My name's Lincoln Caylor. I'm from Bennett Jones in Toronto. I'm part of our fraud law group, and there's a number of us from Toronto in our fraud law group here for this event. Two of them are here, Maureen and Brigitte, and Ruth Promisel also from our group. So we've come in force. What we're going to talk about today is dealing with sovereigns. I want to introduce our panel. Pretty diverse group of lawyers from different parts of the world, and where we overlap is in dealing with sovereigns as somebody to go after. So we're not going to talk about defending sovereigns as much as going after them. So I've got Gonzalo Zeballos here beside me. He's from BakerHostetler in New York. Many of you have probably met him. He's one of the lead litigators in the Madoff case. I promise we're not going to ask him any questions about that. He talks about that all the time. So a lead asset recovery lawyer at BakerHostetler. I think, would you tell me, 35 jurisdictions you've been litigating in around the world? Yeah. So international asset recovery lawyer. Beside Gonzalo, Mark Goodman. He's from Campbells in the Cayman Islands. Campbells is the leading independent firm in Cayman. He's an English and BVI called lawyer. International insolvency and asset recovery. And I think it was in 2016, Mark was recognized as the Lawyer of the Year with respect to restructuring and insolvency. He tells me that his wife is happy that he's away from home, and he's happy to be here and speaking with us. Thank you. Stephane Bonifassi, on my far right, from Paris. I haven't told that Stephane, I was born in Paris. Ontario. Ah. Stephane obviously is not from Paris, Ontario, and he's here also because of his experience in dealing with sovereigns. He is the founding member of his own firm in Paris. He's an asset recovery lawyer. He is also the executive chairman of the ICC FraudNet Group, which is a group of lawyers. We have about 70 lawyers in about 70 jurisdictions. And Stephane leads that group, and it's all for international asset recovery. Stephane also does some white-collar defense work, and what we're going to be talking about here more is the offense work, going after sovereigns to try to get money back for clients. Why is it that we care about sovereigns? Why and when would you ever sue a sovereign? Well, in today's world, sovereigns are participating more and more in business. Think of mining, oil and gas, the list goes on. So you get interactions with them, and you have clients on the wrong end of dealing with sovereigns, and you're trying to get money back from them. So on that theme, why don't we start off, Gonzalo, why don't you start off with us as to why is it and when is it that you'd ever want to sue or engage with a sovereign?
Well, you know, as we look around the global economy, we're seeing a lot more formally command enterprise states like China, Russia, playing an incredibly important role in commerce. And as Link mentioned, if you're doing a deal with a state-owned petroleum company, if you're doing basically any deal with China, last statistic I saw, something like over 80% of the major Russian enterprises are state-owned. If you're doing deals with those jurisdictions, you're dealing with a sovereign. And you need this is at some point going to become an issue for you. Without going into too much detail on the Foreign Sovereign Immunities Act, I think a lot of you here are familiar with it. I think where we're going to focus on is this concept of commercial activity and the commercial activity exceptions and how these play out in our various jurisdictions and how they may be interpreted in different ways.
Do we have any examples of anybody on the panel? So what types of cases have you had, like factually? When is it that a sovereign has been engaged? When are you fighting with a sovereign? Mark, well, is it sovereign wealth funds you're dealing with in Cayman?
We see a lot of investment in Cayman funds for sovereign nations, sovereign wealth funds. We also see a lot of extraction industry structured through the Cayman Islands. We've seen mining, oil and gas routinely structured through the Cayman Islands. And as Gonzalo said, you expect to see somewhere in there some state involvement. So we routinely come across them in that context.
Okay. And one thing we'll touch on a little later, though, terrorism, right? So you think about states, not just business, but more and more Western countries are going after states for terrorism. Have I got that right, Stephane?
I think, Link, you will know about that because there's a law in Canada that allows you to do that, and I think there's a law in the US that's, you know, that's been vetoed by Mr. Obama, but that passed through Congress, and that allows you to, victim of terrorism, to go after states. There's a large judgment against Iran as far as 9/11 is concerned, and that judgment is being circulating around.
Okay. Right. So let's talk a little bit. So there's the why. You know, why would you ever go sue sovereigns, and why would you go after them? Is it different than, you know, Coke and Pepsi fighting litigation or suing an insurance company? Let's talk a little bit about, like, if we're all regular commercial litigators, why would we care? Is there anything different in suing a sovereign?
Right. Well, when you sue a sovereign, it's going to be a lot more expensive and it's going to take longer. The sovereign states have a lot more protection. In the U.S., they don't have to sit through a jury trial. It's much harder to get them to do stuff as basic as discovery. You can get a sanctions order in some of the circuits in the U.S., for example. You can get a sanctions order against the state for not complying, but half the time, all you're going to get is another award that you're going to have to now enforce against the sovereign who you might be trying to enforce with anyway. So I think the two primary factors there are just time and money. It's just it's a more difficult enterprise.
Yeah, there is the first issue is how you overcome the state immunity problem, which seems to be present in all jurisdictions.
Explain that for us. So if you're a company, you're not immune from suit. So what is it? Why is it when you say state immunity, what does that mean?
Well, the position in Cayman is the State Immunity Act 1978 in the UK is extended to the Cayman Islands and the British Virgin Islands, which means that states are immune from suit. There's the common law position back in the day was that the court would not allow a king to be sued. The king can do no wrong. So I say that, you know, the movie Fight Club, where they say the first rule of Fight Club is nobody talks about Fight Club. Well, the first rule of King Club is no one gets sued in King Club. So the state immunity rules are that you can't sue the sovereign, but the State Immunity Act brings about some exceptions. But you would have to bring your claim within those exceptions before you could, so that's the first hurdle. And then once you get over that, there's the practical hurdle. So there is a case in Cayman which is quite insightful called Re-Cybervest, where there was an application by the respondent to a petition by a Kuwait state-related sovereign wealth fund, and the judge, in considering this application for security costs, said, another circumstance of some weight is the fact that the petitioner is a state agency of a foreign government of undoubted resources and enjoying a high reputation in the global financial and commercial community. This is relevant insofar as it would tend to negate any concern that the plaintiff would be unlikely to obey an order for costs made in favour of the respondent. To my mind, it also addresses the concern raised that efforts to enforce an order in Kuwait would be met with a plea of state immunity. And there's a fallacy in that analysis that the state-related entity would A, voluntarily pay a costs award, and B, wouldn't object on the grounds of state immunity to any enforcement. But what it does show is a degree of deference by the courts when they are faced with a state-related entity in litigation. They don't necessarily approach the case in the same way they would if you were a normal commercial party.
If that's right, then we would have no experience in suing sovereigns because they'd always pay.
Exactly right.
So I'm assuming you have some experience where sovereigns are refusing to pay?
They're actually, in my experience, the worst kind of people to sue. And as Gonzalo said, it means that you spend a lot more time and a lot more money dealing with litigation, which against a normal commercial party would have different commercial considerations. They would be more inclined to settle. They would be more inclined to follow the court's orders in terms of discovery and that kind of thing. What you find is that they rather than conduct themselves as model litigants, it's quite the opposite.
And Stephane, in Europe, tell us, what's the sovereign immunity? How does it work there?
I think what we can see is that there was a trend to reduce the scope of the immunity of sovereigns. It used to be an absolute immunity. And let's say from the 70s onwards, you could see that there was the judges were, and there were some interesting case law reducing it quite a bit. Now what we're seeing is the pendulum goes back and sovereigns are being protected. That's why it's making it such a difficult battle. And that I mean, it's a relentless one. And I think in my experience, what you're seeing is that if you want to be successful, you cannot be in one jurisdiction only. You have to try to go wherever you can, wherever there are assets. Yeah. Why is that? Because, I mean, we had the arbitral award against Russia for $50 billion in UCOS. And that is creating in the sovereign immunity world a lot of tension. And we are seeing states and judges being very cautious because Russia is, you know, being extremely proactive to destroy that arbitral award against Russia. What I would say is that as far as Europe is concerned, and that would include the UK for now, is that this issue is dealt with by human rights law. And I know that sounds peculiar to you guys in the US and Canada, but basically, you know, human rights law is more or less what the Constitution law does in your countries. And there are some very interesting decisions by the European Court of Human Rights, which says, one, that the right to a fair trial includes the right to have a judgment enforced, and I think we would all agree with that. Secondly, that when you apply that principle to immunity, and the right to access to a court is the principle at stake, there's an understanding that sovereigns should be somewhat protected when they act in their sovereign capacity, but when they act in their commercial capacity, this protection shouldn't be there. And so there's a string of European Court of Human Rights decision on the topic, some in French, some in English, which are really making the law. And interestingly, because I don't think that's something the US or Canada is seeing, is that basically, there's a UN convention on the topic, a 2004 UN convention on jurisdictional immunities of states and their property, which basically the human rights, the European Human Rights Court says that this convention sets the right balance.
So judges are deferring to states because they assume that the states will be proper actors. You got the practical, they're ignoring you on discovery and stuff. So let's talk a little bit about the practical part then. So let's talk prejudgment. So Gonzalo, why don't you take us to, you have a client who's anticipating that they're going to be able to get a judgment against a sovereign, but they don't have the judgment yet. Is there something like a practical, some steps you should be taking?
Well, in terms of prejudgment remedies, there are very limited options in the United States. Under the Foreign Sovereign Immunities Act, attachment is only allowed if the state has previously consented to it. So if they've waived their immunity to attachment, you can try to get an attachment, but then you have to find an asset that has a direct nexus to the claim. So in practice, the answer would be no, because it would be very rare for you to have a state waive its right to attachment and also still have that asset available to you at the point where you've gotten to litigation.
Is that different in Caymans or in Europe? Can you freeze assets of a sovereign before you have judgment? You
can. There is, firstly, in the legislation in England and therefore in the Cayman Islands and the British Virgin Islands, there is an express exception for immovable property. So a building owned by the sovereign is open to enforcement.
Could you freeze it in advance?
You can. The best example I can give you is an Irish case called Minimco, where the Democratic Republic of Congo was trying to establish an airline. They had a rush of people wanting to buy tickets for that airline, I'm sure. But they bought a plane which was on the ground in Dublin. There was an injunction obtained over the aircraft to enforce a debt of the Democratic Republic of Congo. So the injunction was granted. It was then discharged at the return hearing on the basis that the aircraft was actually owned by Congo Airways and not actually by the Democratic Republic of Congo who had the liability. So the question of whether you can freeze an asset of the government before you have judgment, yes, you can. Your position is clearer on immovable property. Movable property is something that you can seek an injunction over. The difficulty is with cash or cash equivalent assets because if the state can show that they're being used for a state purpose, then it's more difficult to say that's an asset that's available for enforcement. I think the point here is there's two elements to this. The first one is whether you can actually sue, and the second one is whether the state is immune from enforcement. You have your judgment, can you enforce it against cash or cash equivalent assets? Right. The test then will be whether there is, the cash is being put to a state purpose, and if it is, then you can't enforce. So you're going to have a harder time seeking to enforce a judgment against a sovereign nation if it's a cash asset. Your best bet is immovable property, but movable property is also on the table.
Right. So in our jurisdiction, which follows the common law in Ontario, we can get Mareva injunctions against states, and we in fact have, and we've actually got them over securities. So securities, they own publicly traded companies.
Right.
In Europe, is there any prejudgment, attachment, or freeze availability against a sovereign?
In Europe, and I would include Ireland, and since I'm generally acting against states, I wouldn't give that advice too loudly, but I think this case law, this Irish case law you were citing is wrong, because once again, human rights law applies here. Human rights law says that the UN Convention is the right balance and is international customary law. And the UN Convention says that no prejudgment measures of constraint, such as attachments or arrest against property of a state, may be taken before a court or another state. Okay, so that I think, anyway, as far as France is concerned, that would apply. I think it applies in all of Europe.
Gonzalo, tell us about, so if you litigate in the U.S. in the discovery process, there are sanctions. What happens if you have a sovereign who's ignoring you and not responding to your request for discovery or the procedural steps?
Well, as I said before, you have. There's no ipso facto rule barring sanctions against a state. There is a circuit split right now where some courts have said that you can and some courts have said that you can't. In fact, the circuit split right now, the two leading cases are both cases against Congo again, where one court said that there's nothing in the FISIA about getting sanctions, therefore you can't. And the logic was the reverse. There's nothing in the FISIA that says you can, so, you know. So it goes both ways, but both courts acknowledge that getting a sanctions award against the state, your ability to get a sanctions award against the state doesn't necessarily mean anything. And as a practical matter for a litigant, you're often just stuck with another award that you now have to enforce and that you probably won't be able to, especially if it's a money judgment.
So why don't you take us, Gonzalo, why don't you start with sort of the practical steps that you'd recommend if you're dealing with a sovereign then? So limited prejudgment attachment in the U.S. We've heard some, the human rights seen with trumpet, Caymans, and there's some UK law. Now you've got a judgment. So you've got this piece of paper that you're trying to turn into money. Right. Tell us about any practical steps.
Well, the first thing you have to realize is, and I didn't discuss this before, but at least under the Foreign Sovereign Immunities Act, you have two stages of immunity. You have adjudicatory immunity and executory immunity. So the adjudicatory immunity is what keeps you from getting into court with these guys in the first place. And you have to fall into one of the exceptions, which would be, the big ones are commercial, waiver, arbitration, and tort. But that, as I said, gets you into a trial and maybe getting to a judgment, but it doesn't do anything to allow you to execute that judgment. So the next step is look, before you even embark on this path, is to say, how do I enforce this judgment against a sovereign? And to use the example of commercial activity, you have to plan ahead. In the United States, you get the commercial activity exception to allow you to bring suit. You have to rely on the commercial activity exception to execute the judgment. The United States has a nexus requirement for enforcing against a commercial asset. So it's not a matter of just finding commercial assets. If you relied on that exception to get you the adjudicatory jurisdiction the asset you're trying to seize now has to actually have a link, a connection to your underlying claim. So I can't sue you on a contract dispute and then seize an airplane. That has nothing to do with my cause of action. So you have to know that going into it. Under some of the other exceptions, you have broader options. So for example, if you're enforcing an arbitration award, then you have the full panoply of commercial assets to execute against. But these are things that you have to plan out ahead of time. I would recommend to a client, when you have a commercial dispute that you know you're going to enter into, to start planning on identifying assets and assets you want to try to seize several months before you even initiate the lawsuit. A lot of commentators have pointed out that for whatever reason, states rarely start moving assets and hiding assets until they have an adverse judgment against them. So once they have that adverse judgment, they start scrambling to move and hide the assets. So if you're proactive and you start to find and identify assets against which you can enforce, when you get that judgment, then you're in a position to immediately start attaching those assets. Now, that's post-judgment attachment. You can immediately start attaching those assets and recovering those assets. And that was done very effectively, actually, in the UCOS litigation.
Right. Mark, any comments on the practical steps?
Yeah, the position under the State Immunity Act in the UK is very similar. There is, as I said earlier, a distinction drawn between the substantive action and enforcement. But in order to bring the substantive action, you would have to find an exception. And the same as the states, the commercial transaction is the main one that we would expect to see with sovereign wealth funds. A waiver or consent, and that can be an express waiver in an agreement or an arbitration agreement. So we were acting for a Uruguayan mining company structured through Cayman, which was owned by a UK trust and the government of Uruguay. This mining find was valued at $31 billion if extracted. And the Uruguayan government obviously didn't like the idea they weren't getting their fair share of this mine, so they changed the tax laws. And then when we weren't taking the iron ore out quickly enough to make any real difference to the balance sheet, they decided to revoke the mining licenses and give them to someone else, which was then something bought through the London Trust as under an investment protection arbitration agreement between the UK and Uruguay. So the waiver can be expressed in a contract with the state-related entity, or it can be in an arbitration treaty like that. So waiver or consent is the other factor, and then arbitration is under the New York Convention, something which they're taken to have consented to and will be enforced. The big issue that we see is in relation to separate entities. When the state is acting through a separate entity, to what extent can that separate entity assert a right of sovereign immunity? There's an English case called Taurus Petroleum and State Oil of the Company of Iraq, where the State Oil entered into agreements to sell crude oil to Taurus, and for whatever reason, State Oil of Iraq stopped paying them, and they sued State Oil in the UK, and the court, in allowing the claim against the separate entity to be brought, said that it was a question of fact on each case, whether the separate entity was or wasn't a state-related entity. They accepted that exploitation of oil was a state purpose, and so the company could, in certain circumstances, assert the right of state immunity. But it was found that the company through which this was done was a legally distinct entity. It was under the control of its own board of directors, and the government minister had no control over the day-to-day operations of the company. So on the facts of that case, they found that the separate entity was not entitled to assert the state immunity. But you could see how, if the Minister of Oil was the director, or employees of this ministry were the directors, and control was asserted by the ministry over the operation of the company on a day-to-day basis, that this is an entity which could assert state immunity. So what we most commonly see is separate entities, and it's not always clear-cut whether they can or can't assert that right of state immunity.
And in Europe, Stephane, any issues around that?
I think that when it comes to these cases, and it's a good thing that you have various jurisdictions here, because what it's about, you need a leader in the case that has to look at it from a global standpoint. You have to go in all jurisdictions where you have potential assets. And you have to be extremely creative because otherwise you're not going to succeed. The laws are going to be, the immunity is going to be against you, the judges are going to be against you. They want to protect the states for legitimate reasons. So one has to be extremely creative. You need to look at from a global standpoint, and of course you will need information. So lawyers can go as far as they can go from public sources, Google, we talked about that, but I mean, very often you will need investigators as well. Creativity is about, for example, there's a whole discussion about flyover fees. Can you seize them? Can you not seize them? And that varies from jurisdictions to jurisdictions. So you will go to jurisdictions where you have flyover fees. And then there's the separate entity that pops up. And it's twofold, because sometimes you have an award or judgment against a state, and you want to say that the entity is the state, and that it's not separate. And then, and then you have the test you were talking about. As far as France is concerned, it's about whether there are two distinct estates, basically, or whether they are sort of merged, which is the test. But then, so if you've proven that the non-separate entity is an option and that you can go and get the assets of that entity, then the entity is going to say, well, hold on a minute. If I'm not a separate entity, if I'm the states, I'm allowed to sovereign immunity. And that makes it complicated. So the window is very narrow. And that's why, you have to play with the various jurisdictions, with your own ingenuity, your colleagues' ingenuity, to try to make it happen. And they go on, these cases. You must never give up, basically. I was lucky enough once against one of the stands, to attach a plane, a Boeing 777 Boeing. I was able to keep that plane. I think I would have lost at the end of the day. I think I would have lost for many reasons. The plane was belonging to the president of the country, so there was
he'd stolen the money fair and square to buy it?
It was the Republic's plane, let's say. But anyway, I kept that plane on the ground for 6 months, and that really got the president nervous, and we finally settled. So that's the kind of thing. Even if you have to push your cards as much as you can to make it happen. It's a difficult game. It's a great one, actually. It's very amusing when you're successful.
And Gonzalo, do you want to comment on a bit?
Yeah, I mean, I think that I always advise clients who come to us with these kinds of cases, as Stephane said, you immediately think of it as a multi-jurisdictional effort. You're going to have to operate in different jurisdictions. Actually, Link and I have been working on a case together that involves Canada and the United States.
We're under pressure because our clients here.
Because our clients here, yeah. But from the outset, when the case first came to us, the first thought was how do we make this work across jurisdictions? And you have to play to the strengths of the different jurisdictions. So I would say, and this is obviously a self-serving statement, but anytime you have this issue, one of your first stops should be the United States. Because under 1782, you get incredible discovery in the United States. And I would imagine a lot of you are familiar with 28 U.S.C. Section 1782, but it's the provision of the U.S. Code that allows you to get discovery in native foreign litigation. Why is that important? It's important because virtually all dollar-denominated transactions pass through correspondent banks in New York. Through those accounts, you can trace where money goes, who's paying who what. Why does this matter? It matters because A, it helps you find assets, but there's an even more important quality to this. Chasing a judgment, chasing foreign assets is a very difficult exercise and requires tremendous creativity. And you're not always going to monetize an award by finding an asset. Sometimes you just have to be a pain in the neck. And you got to look for transactions. You got to back into it. You got to look at where money's being paid from and then try to get to those accounts. One of the things that we've done in our case is identify commercial counterparties and say, okay, the money you're paying the state now has to come to us. And try to find as many of these transactions that are happening as you can and try to get in the way. Even if you don't win, eventually, as you get in the way and start blocking these transactions, you start to be enough of a pain in the neck that it generates real settlement pressure to make the case go away. If you can get discovery for things like if you can find a law firm that's advising on a commercial transaction, you can find the account they're getting paid from. You can try to get into that account. It's very annoying. It's not a tremendous amount of money, but you have to be a gadfly. Eventually, it starts to have an impact.
And that's, I think what Gonzalo was saying right at the start is it's a more expensive, more time-consuming exercise. Because you're exactly right, we've got a case right now where there's $6.5 million sitting in a bank account in DC. We know it came from the bank that we are dealing with the liquidation of. There's been interpleader proceedings on foot in DC for years now, 6 or 7 years this has been going on. And the Brazilian government, who's interpleading based on a confiscation order, is just not behaving in a manner that a usual litigant would. No consideration at all of settlement discussions. They fired their lawyers in the US just so they didn't have to turn up at hearings. We get no interaction from them at all. And what it takes to be that gadfly that eventually grinds them to a point where they either come to the table or you find some other way of monetizing your judgment is an expensive and time-consuming exercise.
What about publicity? Any experience there or comments on that?
Yeah, I mean, it's an interesting tension because there's a time to make a lot of noise and there's a time to be very quiet. When you use a discovery tool like 1782, you can do it under seal, you can do it with a gagging order, or you can do it very publicly. It just depends on what your approach is. If you're trying to be a gadfly, I think one of the things that, for example, that you can try to do is get discovery on things like oil and gas contracts, try to identify who the parties are, try to get the terms of those agreements. States really do not like those things being made public. So that's an example of where having a very open proceeding and having people know exactly what you're doing is helpful. If you can identify assets that are the fruits of corruption, and to this extent having a good relationship with regulators and law enforcement people in your own jurisdiction is very helpful. You can find those assets and start digging into that discovery and start seeking discovery to find the names and persons behind that. That can be very embarrassing for the state. So when you're taking these steps, when you're gumming up commercial transactions, I think it's very helpful to actually have a coordinated PR campaign with the right people getting out there, getting your actions into the press and creating as much embarrassment for the state as you can, always within the realms of a good faith proceeding, but trying to make it difficult for them. And PR can be an invaluable tool for that. Other times you want to be as quiet as possible.
It does depend on who you're involved with. There's obviously some states who care more about their perception in the international commerce markets than others, and that's reflected in the fact that China is absolute bar on claims against the state. Hong Kong, same. Russia. I had a client who was involved in litigation with various state-related entities in the Middle East, Qatar, the Bahrain Pension Fund, Dubai. He was invited repeatedly to Qatar for a settlement negotiation with them, and he was absolutely convinced that if he went to Qatar, he would never be leaving. So it depends who you're dealing with, but I agree that the way you have to do this is, particularly from a Cayman perspective, where we never find assets in the jurisdiction, you're always looking internationally at where assets might be to enforce, that you have to take a global view and you have to have a joined-up strategy about how you're going to make the recoveries.
Just to add really quickly onto that, and some of the circuits in the United States, the discovery that you can get is not limited to documents and materials located in this jurisdiction. I've had the experience recently where I've had a subpoena against a bank to get documents produced that I know are in London, but that I can't get from any other proceeding. And I filed that action here in Florida. It was funny because on the first phone call with the lawyer, she says to me, well, it seems to me that you're just filing this lawsuit in Florida because you're trying to get documents that you have no other way of getting, even though they're located abroad. And I said, yeah, it's exactly what I'm trying to do. It's exactly what the law allows me to do. But it's an example of bringing a discovery action in the United States with the absolute intent from the outset of filing a lawsuit, in that particular case in continental Europe. And that's what I mean by using the United States to fuel your litigation in other jurisdictions.
Right. Stephane, any comments on PR or cases you've had where the sort of publicity has been an important aspect?
Honestly, looking at these countries, if you take Congo, we've been mentioning Congo many times, they don't seem to be that mindful of their image in the public, because, I mean, if there's something certain, is that they are not good payers. And I think the whole world knows this. So I'm not sure, but it will depend. If you look at Russia, Russia has a PR strategy on the UCOS case, for sure. Are those? I'm not involved on the demand side here, but are those who are winning that PR battle? I don't think they are at this stage. I think they're losing it. So you know, there might be instances where PR and publicity is concerned. What I find interesting as far as Congo is concerned is that I've managed to seize a piece of property, a flat in Paris, which is worth 1/10 of what Congo owes me. And that piece of property must have hit something special because I got a deal out of Congo, because I had seized that, not that such a grand flat, you know, an ideal flat for having a nice afternoon or something like that, but nothing more than that. And somehow
that hit a nerve, I guess. Right? Yeah. Right.
So you have to, you know, you have to try, because as you say, Mark, the 6 million bank account, the money doesn't belong to any individual that has a concern over it. They sometimes don't care. Yeah. You can have seized it. You may win over it in 10-year time. Well, okay, you'll win it. No one will care. So it's about, you know, and Gonzalo, you're right. If you can reveal shady deals, that's always a good one, I would say.
Any questions at this stage for these guys? Fighting states? Nobody cares? Natasha?
One at the front, Nick.
Sorry, right here.
So you had mentioned that seizing the flat really hit a nerve with the Congolese government. Do you now, after having done that, do you incorporate it as part of your, I'm all right, my voice carries.
It's not for the recording.
Sorry. So you had mentioned, for the recording, so you had mentioned that seizing the flat had really hit a nerve. Now, as part of your recovery strategies, do you try to focus on trying to find assets that might be of particular importance or of particular use to one or two ministers within the government that could then pressure them into settling, or?
In France, we have this ongoing saga about ill-gotten assets. And some countries are involved in that. Equatorial Guinea is one of them, but there are others. And that's something I'm looking into, and I'm not the only one actually, because that's hitting a sensitive spot. You know, we are talking about assets that should be belonging to the state, but that belong nominally to some of the president's family. And that's something we are looking into in some of the cases.
Well, presumably, the idea here is if you find something like that, it's an element of luck. But
Right.
if you deploy the right strategy, you get lucky more often. So if you have got a cohesive strategy how you're going to approach identifying and enforcing against assets globally, you are going to hit upon those things which are of more concern.
Yeah. If there were a way to target those assets, it would be wonderful. But in reality, what you wind up getting is a pile of records and papers, and you sift through them, and those are the assets that you find. And this was the point that I was getting at a little bit earlier with backwards versus forward asset tracing. It's when you find an asset or a commercial asset in the state, you then have to take that asset and try to trace back to where, or trace forward to where it's going to and what it belongs to and how it's being used if you have to create a nexus. When your discovery identifies a transaction, you know, so you're seeing money flows going to one entity and going back to another entity, what you can do is trace backwards to an account. So if I find a transaction where somebody's being paid regularly, you know, for services, for example, from an Antiguan bank account, I know that that's a commercial bank account because it's being used to pay for services. And that's something that is something that helps me out if I can identify it, or any state. That's a huge advantage to me because it's already a commercial, an identifiable commercial asset. The difference there is one is one you want to do with a big publicity extravaganza, and the other one you want to do quite quietly. But in terms of targeting, I think we'd all love to be able to target sensitive assets, but I don't know how you would do it.
We have a case where we actually, to show you the scope of these 1782s, we got bank account information from the state's lawyers, because they were using the bank in which was subject to Gonzalo's team went and got that, which we disclosed to the other side. But talk about sort of, they're obviously seeing their most confidential information, money, large sums of money from their lawyers being transferred to them. And
Right.
so that was a good pressure point, and just shows the detail you can get from these bank accounts and the scope of the 1782.
Yeah. But we didn't know we were going to get that.
No,
so
yeah,
we got it.
yeah.
That's sort of the catch, you know. And you have to be able, you know, you need a team that's going to see that and identify that that's, you know, because what you're getting is just sheets of numbers and names, and you have to be able to connect the dots and see what that actually means.
Elizabeth Ortega, Eco-Strategic Communications. In terms of pressure points that you're talking about in public relations, are you seeing that you are using publicity as an overall, a given as part of your strategy? In other words, are you seeing an increase in that area? And if so, why do you think that is?
I personally use PR in almost all litigation that I'm involved in one way or another. I think properly utilized, it's an incredibly powerful tool. I think it's an underutilized tool. But I actually find that it can be very effective. It can also be a blunt instrument, and it can be overused. You have to be judicious about it. But I think when you use it as a scalpel, it's very, very effective.
We are seeing a lot more of it. I've been involved in a case recently where an article, it was the Wall Street Journal were paying attention to a particular case we were involved in, and we engaged with a PR specialist who was able to bury the story for a time. When the story eventually broke, it knocked 15% off the share price of the asset that we were concerned with, which was about $30 million. So PR, I agree with Gonzalo, is now an essential part of litigation. In this kind of commercial work, it does make a really big difference.
I've had one case settle completely because of PR, which I can't give any details about, unfortunately, because the settlement was confidential.
That's exactly why I posed the question.
It was 100% because of the PR.
I've seen, in terms of pressure points, again, I've seen the tremendous advances that cases have made towards settlement because of a strategic and well-timed, right, publicity strategy.
And that seems to be particularly true of the Chinese market. There's a lot of face involved in this. There's a lot of people protecting their reputation, litigating because they don't want to be seen to be backing down. And the way the PR plays into that means that you know, somebody is going to look much worse than they thought. Or, you know, there's a chance they might come out looking better than they thought. And so the use of PR it really helps to break that down.
I would say that your client is who is your client is going to be important here. Yeah. Of course, yes. If you have terrorist victims, the PR operation is going to be fruitful, I would say. If you are dealing with a large company that has won through an arbitral process, which, you know, some countries will question the transparency of the process, like Russia is doing as far as UCOS is concerned. I would say that PR is needed, but winning that battle is going to be a tough one. I think it's going to be a battle of equals here. And actually, as far as UCOS is concerned, the arbitral award was set aside where the seat of arbitration is, that is in Holland, right? And I think that the fact that Russia was so vocal about it certainly had a role into that surprising decision, let's say.
I did deal with a case where Deutsche Bank was listed as the first defendant, and the first plaintiff, one of the investors in the fund, was the Miami Children's Hospital. And the whole case theory was, well, put this case in front of a jury. It's the Miami Children's Hospital suing Deutsche Bank. Who's going to win? Right.
That's a it's a jury strategy, right?
Yeah, that was a US litigation out of a Cayman liquidation.
Right. Yeah. Any other questions? Glenn Pomerantz, BDO from New York.
So are you able to jump ahead of ordinary course liabilities with a provider that the sovereign is dealing with. So you identify a provider that owes a debt to the sovereign, but it's an ordinary course liability. You know, they're providing a service to the sovereign. You figure that out. They owe money to the sovereign. Can you jump ahead of that sovereign, that creditor, and attach the money owed to the sovereign?
I want to make sure I understand your question. So the money flow here is you have a service provider, the sovereign, and the money's flowing towards the sovereign from that. The answer to that is yes, depending on which exception you fall into on the executory jurisdiction front. So if I've relied on the commercial activity exception and I can't tie that money flow to my transaction, then I can't get to it because it's a commercial asset that's not linked to my activity. If it's an arbitral award and there's proper waiver and you have either implied or express waiver, and that's a commercial asset, I should be able to get to it.
So it has to have something to do with your matter. It just can't be some random debt.
If I've relied on the commercial activity exception to beat immunity in the absence of a waiver or something broader than that, yes, it has to have a link. And that's not the case in other jurisdictions.
As far as France is concerned, it's a shady one because we copied the US concerning that link between what you're attaching and your claim, and that was the case law. I think it's not valid anymore, but it's still unclear. But would that service provider, then the test would be, would that money flowing in, would that be commercial? Yeah. Or would, and the state is going to say, well, what these people are paying me are taxes, they are not fees, or they are not, you know, well, but they make that claim and they sometimes win it by saying there are taxes. You are seizing taxes here. You cannot seize that. And, it's been successful. That defense has been successful, not always, of course, but has been sometimes successful. For example, in France, as far as the Argentina NML case is concerned, that was successful. Argentina claimed that what was attached with oil companies were taxes, and that went through. The French courts accepted that defense, and that couldn't be attached as a result.
There is case law, by the way. It's not an entirely clear-cut thing on whether money payments comprise a commercial asset. So it's not going to be as clear-cut as all that. So as Stephane said, sometimes you win, sometimes you lose on that. But in principle, it can be done.
Thanks.
And in fact, we're seeing that in a case where we're doing exactly that. So there's two things: will you ultimately be successful? Will it be upheld, the getting in the middle of the transaction? But there's also, back to the point the panel's been making, is just get in the way.
Just get in the way.
Get in the way so that these payments are stopped. And then you have the sovereign saying, well, why am I not getting that income stream or the payment stream? And then maybe there's a point to negotiate that. So it's getting in the way is also important. You might ultimately lose on some of the points.
Although what we are seeing, for example, if you talk about, an oil company or an airline, for the flyover fees, for example, if you seize them, they're going to go back to the company and say, you haven't paid me, you should pay me back. So we have a second enemy here, which is not only the state, but the service provider who's been attached and who is being under pressure from the sovereign to pay twice. And so they are coming against you and asking you to lift the attachment on various, saying it's not commercial and that you should lift that attachment. Sometimes I'm not seeing the sovereign at all in the proceedings. I'm only seeing the service provider.
Last comments to wrap us up. Do you want to just go through the panel? Gonzalo, do you have any last points you want to make?
I just want to close one more loop. So when I was talking about backwards tracing, you identify an account, for example, where a service provider is being paid. I didn't mean to suggest that you could get in between that payment. But what you can do is identify that account as a commercial asset. So you can try to seize the assets of that bank account. So just to clarify that I was speaking about two different things at that point. The only point I'd make in conclusion is that this is, is a very It's a very difficult area of law. It's one that you have to think about as not as how do I find assets and recover them, it's how do I monetize my award. And in terms of monetizing your award, that can mean many different things. That can mean finding assets and tracing them and recovering them. Frankly, that's rarely the case. You usually get your money from other sources. It also can mean finding counterparties. It also can mean pressuring for settlement. But whatever you have to do to monetize that asset, that's your end game. And ultimately, there are other options that are extrajudicial that you can always rely on if it's really not working. You can sell your claim to institutional traders, or one very, very drastic option is if all of this isn't working, you have the option of the claimant being put into liquidation, so that you can take advantage of all the cross-border insolvency laws that allow you to recover assets and transactions, or you can try to put the debtor into involuntary liquidation. That will usually only work if you're dealing with a state entity or instrumentality. But again, these are all different steps you can take with an eye to monetizing your award as opposed to thinking of it as just an asset recovery. If you go into this as an asset recovery exercise, you're just going to spend a lot of money and you're not going to get anything in the end.
Any last comments? We just have a minute or two. So.
I totally agree with Gonzalo that what we're concerned with is monetizing, taking some money out of this situation. What you'll find is if you try and sell these claims, even after judgment, you get so little for them. We've recently tried to sell a judgment debt, and we were offered about 2.5% of the value after a bidding process. So you will lose a lot of value in that way, but it might be your best option given the alternatives. Liquidation is always a great option from a Cayman perspective because you have so much more in the way of investigative powers of compulsion, and we also have a more relaxed regime when it comes to things like assignment of litigation claims, funding of litigation. So I would always give that some consideration. But the one point you should take away from this talk is that if you have the choice to pick a law to govern your agreement with a sovereign nation, go for Australia. That seems to be the jurisdiction which is most favourable to the non-sovereign party.
Then the question is how you enforce your Australian judgment, which might not be as easy as that. No, I think it's a field which is, we are seeing a lot of interests. The interest of France, as far as I'm concerned, the Foreign Office. Those are cases where I regularly see at the hearing the public prosecutor coming on a civil case to say why I'm wrong. So, but I like a good challenge. So, and I think you guys too. So that's why it's. But it's one has to be creative in these cases for sure.
Great. Any last questions? Help me thank our panel.